public information.
You're acting tough now? You're acting tough now? Behind the bench?
Let me finish, and I'll let you speak, all right?
Yelling at me now?
Yes.
That constitutional? I would like for everything to be dismissed, if it pleases the court. It don't matter, because I don't understand how y'all run y'all system. Y'all practice against the law. You are totally infringing on my rights.
All right, everyone. This case gets extremely intense right from the start. We're dealing with a very unstable sovereign citizen who completely loses control during the court hearing. He jumps from topic to topic, speaks nonstop, and the audio quality makes everything even harder to follow. On top of that, his behavior toward the judge is highly inappropriate and disruptive that I'd really like to hear your thoughts in the comments about how the judge handled the situation. In my opinion, the judge stayed professional and calm, even though these types of defendants constantly push limits and create unnecessary chaos. I'll step in occasionally to share my own reactions as things unfold. So let's get started and take a closer look at what happens next.
And it looks like the rest of this stuff he's already entered a plea into all this stuff.
No, sir. No plea.
Well, that's not what it says here, sir.
I represent myself. I couldn't enter the plea. I never plea. You can check my record. I never plea.
Oh, maybe I found you guilty then. Yeah.
No, I haven't been. Matter of fact, I came inside there personally a week or so ago. And the young lady, the security officer, came out and said that I'm supposed to report today.
No, this is on some old stuff. All right.
I never entered the plea.
So do you not want the representation of counsel?
No, thank you.
Okay. There you go, Mr. Take. That's your first break of the day, Mr. Soroki. You know what I mean?
Judge, I know how to deal with everybody. So I said I know how to deal with everybody, any type of client.
Yeah, I know, but he doesn't want
right,
it. So
I understand.
We can't force it on him.
No, I understand.
Yeah. So you can
take it as a plus.
As for purposes of arraignment, sir, we'll do it like this. I'll enter a not guilty.
Are you talking to Mr. Hicks or Mr. Lee?
Pardon me?
Yes, you should be able to follow the first.
Are you talking to Mr. Hicks or Mr. Lee?
Mr. Hicks, I'm sorry.
You should be down on area code 929.
Mr. Hicks, for purposes of arraignment, I'm going to enter a not guilty plea on your behalf and give you a $0 bond, all right?
I object, Your Honor. That would be practicing in front of the bench. I object. That would be practicing in front of the bench. Practicing law from the bench. You will have to recluse yourself if you hold on to that.
All right. Well, I deny your motion. So go ahead. How do you want to proceed?
I would like for everything to be dismissed, if it pleases the court.
We're only about 3 minutes into the hearing, and this person is already pushing for the case to be thrown out. What's confusing is that people who claim the court has no authority still show up on time, follow basic courtroom rules, and respond to the judge, yet continue arguing that the court doesn't apply to them. That contradiction never makes much sense. It's hard to understand what outcome they're expecting. Courts don't work based on personal beliefs or feelings about the law. Legal authority comes from clear factors, like where an incident happened and which laws apply, not whether someone agrees with the system. You can't simply argue your way out of a case by rejecting the rules, me. It feels like this approach is meant to slow everything down and drag the process out as long as possible. But I'm curious what you all think. Drop your thoughts in the comments. For now, let's jump back in and see how this continues to unfold.
Deny. What basis?
You haven't even let me tell my grounds.
All right, basis. Give it to me.
For one, a ticket is a bill of attainder. Article 1, Section 9, Clause 3. of the Constitution of the United States, no bill of attainder or ex post facto law shall be passed. You cannot have a written assistance
All right, let me
to
stop.
equity that transmitted into law penalties.
Let me stop you right there. Let me stop you right there. We have, first of all, we have a problem with the transmission. You're breaking up really, really, really bad, and we can't get that on the, turn your video
I
off.
understand.
Maybe turn your video off, that will help. Let's see.
Article 1, Section 9, Clause 3 of the Constitution of the United States. No bill of attainder or ex post facto law shall be passed. You cannot have a writ of assistance that has civil equity that transmits into law. Number 2, there is no sworn statement from an injured party. Number 3, the officer did not even sign the ticket. That's under law of penalty of perjury. I'm asking that all of these be dismissed.
All right, I'm going to deny that motion. All right, how else do you want to proceed?
That's your declaratory judgment?
I'm going to deny the motion. I denied the motion.
Okay, let's go to court.
Trial?
It don't matter, because I don't understand how y'all run y'all system. Y'all practice against the law.
So now he's claiming that the judge is the one breaking the law, while he insists he's the only person in the room doing everything correctly. That argument alone is hard to take seriously. He speaks with total confidence, yet it's clear he doesn't actually understand how the law works or how courts operate. Judges spend years studying, training, and working within the legal system every single day. Meanwhile, this guy seems to be relying on things he picked up from a few online videos, and acting like that makes him an authority. Watching him try to lecture the judge is honestly baffling, especially when the judge clearly understands the situation far better. What stands out most is the complete lack of self-awareness. He keeps throwing out random claims, raising his voice, and repeating the same points without stopping to reflect. I can't tell if his behavior comes from the sovereign citizen mindset itself or from something deeper, but either way, it's strange to watch. Let me know what you think, and let's jump back into the hearing.
I'm a common law.
Well, read the court rules, and you'll learn a little something.
The court rules go against the law. Y'all practice against the law, against the Constitution. I'm all common law.
All right. Well, we're beyond that.
Okay.
All right.
So you say. So are you going to prosecute this, or somebody else going to prosecute it?
Stop. Let's not keep going. All right. You want a trial date, or not?
It's up to y'all. Remember, y'all make all the rules.
Trial date. You want to, let's give him a jury trial date.
Jury trial.
Yeah.
How long do I have to turn in my briefs?
I'll give you some dates in a second.
Okay. Scamming. With a smile on your face. If it pleases the court, what jurisdiction are you charging me on?
I asked the question, sir.
I just said if it pleases the court.
I know, and I'm telling you, I asked the questions. I appreciate your
We can do it.
your respect for the court, but I asked the questions. I told you to read the court rules.
We can do it. March the 5th. Let me check and see.
The court rules.
Is
What
March the 5th?
jurisdiction are you trying to charge me on?
Is March the 5th a good date for you, sir?
No.
June the 11th is going to be the jury trial date.
June the 11th?
June the 11th. So let's put your final pre-trial date will be, let's see, put that a day before. That way, that'll be the date we'll argue motions on June the 10th. May the 24th will be your motion, and now
May
city,
24th.
May the 24th, and the city will have 7 days to respond. So the response to the motion will be due by May the 31st.
I appreciate you, Your Honor.
All right, have a very good day, sir. Best of luck to you.
I just did.
So that wraps up the first hearing. But this situation is far from over. This individual returns for a second appearance, and things quickly become much more intense. The tension rises fast, and the tone of the courtroom shifts almost immediately. During this next hearing, he becomes extremely upset over a small paperwork issue involving an incorrect date. Instead of addressing it calmly, he reacts strongly and turns the moment into a full breakdown, directing his frustration at the judge. This is also the point where his behavior crosses another line and causes serious concern in the courtroom. Before we move forward, let me know what you thought about how the judge handled the first hearing. Did you think the judge stayed in control, or should things have been handled differently? With that said, let's jump into the second hearing and see how it all unfolds from here.
What are you here for, sir?
The slip says for Jonathan Reeves.
Jonathan Reeves.
Yes.
I don't know anything about a Jonathan Reeves. Let's see. I don't know anything about a Jonathan Reeves.
Well, I motion for this case. Man.
Are you Mr. Hicks? Are you Albert Hicks?
Yes, I am.
Okay, so we're gonna get you your dates, and that Jonathan Reeves.
I already have my dates. I talked to you last week, remember?
I think it's correct.
I have June the 10th and June the 11th.
Very well. Okay, we'll see you back on those dates, sir.
But this matter right here with this Jonathan Reeves.
Well, what does Jonathan Reeves have to do with you?
That's what I'm here for court for today. I'm making a personal special appearance for this.
Okay, I don't know. Who is Jonathan Reeves? Do you know who that is? What does it say on that? Because it sounds like it may be Jonathan Reeves may have stayed at that address at some point and left. I don't know what that's all about.
That's why I'm asking that this case be dismissed. The case is SP 1500-8721.
SP 1500-8721. Okay, that's not Jonathan. Okay, Jonathan Reeves is the officer that apparently wrote the ticket, and that's scheduled for the final pretrial on. I see where he's here today. It says scheduled for pretrial today, but that's all going to be handled on the 11th of. Jonathan Reeves is supposed to be here on the 11th of June, on the day.
I was not notified. 11th of June.
Yeah.
How is he going to be here on the 11th of June? And I have Spidell on the 11th of June.
You have a couple of different officers, obviously.
Jonathan Reeves and Spidell has nothing to do with each other.
Well, we're just consolidating. We're having all of them.
Why would you do that against my will? Why would you just do that?
I'm doing it because of the judicial economy, sir. So
I'm challenging that one.
Okay, then write a motion, and we'll rule on it. But it's all in the same. We're all going to do it on the same day.
You didn't ask me that.
I don't have to ask.
You didn't ask me that. You just arbitrarily did it. That's not right. That goes against my rights.
All right. Well, you can put it in a motion, sir.
Well, the whole thing is, I don't know what y'all doing down there, but you are totally infringing on my rights.
It honestly feels like the more upset this person becomes, the worse his microphone sounds. The audio keeps cutting out and breaking up. almost like his anger is overpowering the connection. It makes everything harder to follow and adds to the overall chaos of the moment. This situation checks every familiar box: poor camera quality, terrible sound, and a strong sense of disconnect from reality. As the hearing goes on, his behavior becomes more extreme instead of calming down, which only makes things more uncomfortable to watch. The longer it lasts, the more surprising it is that the court continues without stopping it. What really stands out is the judge's level of patience. Many people would have stepped in much sooner, especially with someone speaking this way while keeping their camera off. The tension just keeps building, and it's hard to believe this is still unfolding in a courtroom setting. Let me know what you think about how this is being handled, and let's jump back in.
Okay, well, file a motion, sir. That's how you speak to the
Why
court.
would I have to file a motion when you infringed on my rights? And I'm saying it right here, right now.
That's what the court rules are. You gotta follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything here. That's all public
Oh,
information.
you're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks. Let's not go there, all right?
My honor, please. I'm bringing up valid litigation for this. I don't know what y'all doing. Y'all can't do anything without my permission. I'm not a ward of the state.
Mr. Hicks.
I'm an unfranchised common law free man.
Mr. Hicks. All I ask you to do is you can file a motion. You can put all of that stuff in the motion.
Yeah, so you can come back and say motion denied, right? Like you did last time.
Well, that's my discretion. If I don't feel that if it doesn't meet the criteria of the law, then that's what my
What jurisdiction are we?
I'm not going to answer this question, sir.
Oh, you're not going to answer the questions? Then I would like to know your status.
You don't ask the questions. I ask the questions. That's how.
You're going to play like that. What is your status? I am a common law free man. What is your status?
Mr. Hicks, I'm about to put you out the room, and I'm going to do that so I don't have to find you in contempt. I don't want to do that. Okay? I'm giving you your opportunity to speak to the court through motions. You have your motion date already set. You can put all of that stuff in the motion, okay? And
why wasn't I notified about this case, this particular?
You are notified. You have it here. You have it there. That's why you zoomed in. All right, Mr. Hicks. All right, now I'm going to give you one last chance to speak, sir. Go ahead and well, before the other litigants come on.
And Your Honor, we're not on the record with Mr. Hicks.
No, we're not on the record.
We should be on the record with Mr. Hicks.
We're not. You don't have a court date today, sir.
I have a court date. I have the paper right in my hand. I have the paper right here in my hand.
In that case number, I told you your court date is, you have motion dates for that. You have,
you just told me, you just told me that. What did I have a court date today for? Why did I waste my time to come here just to hear this?
Well, I mean, sometimes that happens. I mean, if you feel that you're wasting your time, then you don't.
It's the fault of mine. It's the fault of 36th District. Y'all asked me to come to Zoom today.
From what I see here, sir, it's
it has pre-trial on here. Wednesday, February 7th, 2024. 9:35 a.m.
All right, let's do this. Let's call the case.
Zoom hearing meeting.
Hold on a
for
second. Let's call the case. Let's call the case. This is the city of Detroit versus Albert Hicks Jr. Case number SP15008721. State your name for the record, please, Mr. Hicks.
Albert Hicks.
Today is the date and time, we'll call it, set for a pre-trial date. I see here.
This is supposed to be the trial, excuse me, Your Honor. This is supposed to be the trial date.
It's supposed to be the pre-trial date, correct?
Absolutely.
Okay. Mr. Hicks, based on the nature of the allegation, the city's not going to give you an offer for this case. They want to see and speak with the officer, one being the gentleman you referred to off the record, Jonathan Rivas, and then there's another officer, Daniel Colgrove. Either one of those officers, they're both going to be summoned. I don't know what their testimony will be, but
I motion to dismiss.
Let me finish, and I'll let you speak, all right?
Yelling at me now?
Yes.
Is that constitutional?
All right?
Over. Okay.
So let me finish, and I'll let you speak. If you're not going to do it that way, you're either going to get out the room or you're going to be in, I'm going to lock you up. All right, so today is the date and time set for a pre-trial. And this pre-trial, the officer is not required to be here for a pre-trial. The pre-trial date is set in order for you to get an offer to either settle up the case, or in this case, we're setting a trial date. You have dates already set. The date motion due is going to be on May the 24th, 2024. The response to that motion, if the city chooses to respond, is going to be on May 31st, 2024. Your next court date that you need to be present is going to be on June 10th, 2024 at 8:35, with the jury trial set the next day on June 11th, 2024 at 9:35. Okay? Now, I'll let you speak, and we're going to end.
Is all of this on record?
This is all on record.
Is all of this on record?
Yes.
Okay, please send the information to my home, please.
I find it interesting how he squeezed in that final comment about having the paperwork sent to his home address. At that point, it feels pretty clear where this is headed. It wouldn't be surprising if his next step is missing a court date and then claiming he never received anything. That pattern shows up again and again in situations like this. This approach is very familiar. Deny responsibility, redirect the blame, and then act surprised when a situation falls apart. If people with this mindset spent even half as much effort learning how the legal system actually works as they do arguing against it, they might avoid getting into these problems in the first place. Instead, they rely on ideas that don't hold up in real courtrooms. That IT does make you wonder how someone convinces themselves that they can simply opt out of laws altogether. On the surface, it can seem almost unreal, but there's also something genuinely concerning about it. The level of denial required to believe this way is hard to ignore, and it raises serious questions about judgment and reasoning that I'm curious what you all think about this individual and how the situation played out. I'd also like to hear your thoughts on the judge. He comes across as fair and composed, though some might feel firmer action would have been justified. If you enjoyed watching this case unfold, be sure to like and subscribe for more content like this. Thanks for watching, and take care.